Thank you for tuning in to the Brach Eichler Talks podcast, where we explore and discuss today's trending legal topics. In this episode, we'll discuss a recent labor and employment alert from Brach Eichler titled Refining Diversity Programs, Greater Federal Specificity. Since January 2025, when the second Trump administration began, the federal government has trained its sights on DEI programs. Many of the government's early initiatives did not specify what types of programs would be considered illegal. The closest came from the EEOC in March 2025, when it issued guidance that a DEI program may be unlawful if it involves taking an employment action motivated, in whole or in part, by race, sex, or another protected characteristic, and that unlawful limiting, segregating, or classifying workers related to DEI can arise when employers separate workers into groups based on race, sex, or another protected characteristic when administering DEI or any trainings, workplace programming, or other privileges of employment, even if the separate groups receive the same programming content or amount of employer resources. The federal government has now published more specific guidance in the form of a July 29, 2025 memo from Attorney General Bondi to all federal agencies. Although this guidance is limited to recipients of federal funding, many private employers receive federal funding, e.g. Medicare and Medicaid, and its principles apply to all federal non-discrimination laws. The Bondi memo identifies the following 4 types of diversity-related actions that violate federal non-discrimination law unless they meet very narrow exceptions. 1. Preferential treatment. Cited examples include A. Financial rewards, scholarships available to persons based solely upon their protected characteristics, such as a woman-only scholarship. B. Prioritizing job applicants based upon their protected characteristics, such as requiring a diverse slate of candidates. And C. Providing resources based solely upon a person's protected characteristics. 2. Using proxies. Some employers have, in lieu of considering a person's protected characteristic, come to rely upon information about the person that may correlate with the person's protected characteristic. Per the Bondi memo, such proxies are equally illegal when the proxy was selected because it correlates with a protected characteristic and the employer implements the proxy with the intent to advantage or disadvantage individuals based on protected characteristics. 3. Segregation. Similar to providing resources based solely upon a person's protected characteristics, illegal segregation arises, according to the Bondi memo, when an employer forces employees to differentiate themselves based upon their protected characteristics. Cited examples include a DEI training group where participants must separate into race-based groups, e.g., Black Faculty Caucus or White Ally Group, for discussions, prohibiting individuals of other races from participating in specific sessions, and awarding set-aside contracts to a contractor based solely on the contractor's protected characteristic, such as being female or minority-owned. 4. Training programs. Training programs that stereotypes, exclude, or disadvantage individuals based on protected characteristics may be illegal if they create a hostile work environment or impose penalties for dissent. Claiming that something may be illegal is far different than a judicial decision finding that a particular practice was illegal. Nonetheless, employers, in consultation with counsel, should carefully review the Bondi memo as part of continuing efforts to refine workplace diversity programs in this new enforcement climate. For more information about your organization's diversity initiatives compliance with anti-discrimination law, please contact jsabin Esquire, Member Labor and Employment Practice at 917-596-8987 or jsabin@bracheichler.com. Don't forget to subscribe to our podcast on Spotify, Apple Podcasts, and YouTube. Follow us on LinkedIn and Facebook for updates on new episodes. For more information and resources, visit bracheichler.com. This is intended to provide general information, not legal advice. Please contact the authors if you need specific legal advice. Brach Eichler LLC is a full-service law firm based in Roseland, New Jersey with over 80 attorneys. The firm is focused on the following practice areas: healthcare law, real estate, litigation, trusts and estates, business transactions and financial services, personal injury, criminal defense and government investigations, labor and employment, environmental and land use, family law services, patent, intellectual property, and information technology, real estate tax appeals, tax, and cannabis law.